Hello, my name is Brandon Riley. I am a partner at Manat, Phelps and Phillips. We are a national law firm. I'm a member of the privacy and data security practice at Manat and a resident of our Orange County office. I wanted to thank ISACA, the Orange County chapter, for having me. This is, proud to say, my second year at the second year of the CCPA forum. It's a great event, and we really hope that you guys are getting a lot out of it. As I know you all know, the CCPA is really the preeminent privacy law at this point in the United States. It's the de facto national privacy law. So the subject of today's programs are incredibly important. What I'm going to do with this presentation today is I wanted to take a step back. I know that many of the other presentations are really digging into the finer points of the CPRA as well as the CCPA, looking at enforcement, looking at how does the CPRA differ from the CCPA? How does it differ from the GDPR? I'm not going to do that with these 30 minutes. What I would like to do, I think, is really take a step back. I found that it is important for compliance professionals, and especially professionals in IT and in security, to really understand where we've been when we talk about compliance with privacy laws, and to understand where we are and where we're going. And that's because privacy law and regulation is really changing fast, as I'm sure you are all experiencing in your everyday work this year in 2020 in particular. What I've found working with clients really of all sizes is that business leaders can be easily overwhelmed. They may have an attitude of, well, let's wait and see because of all the changes that are happening so fast. They may have an attitude of, I'll believe it when I see it, right? So for instance, they may be presented with an incredibly complex law like the CCPA, but they don't really see it impacting their peer businesses or their own business in a meaningful way, and thus they're not prone to take it seriously, at least immediately. Or simply they may have the reaction of, I just don't understand why this is important. And so it's our job as privacy professionals, as compliance professionals, as IT professionals, to really help our business leaders along. And I think an understanding of the history of regulation and its broad trends is vital to enable you to communicate the need for strong investment in compliance and robust governance. This is so important. So again, what are we going to do? How did we get here? Where do we stand now, and what does the future hold is what I'd like to quickly go over. Again, thank you to the ISACA Orange County chapter. I know you guys all have information about the chapter at your fingertips. Here's a little bit. Again, my name is Brandon Riley. I'm a partner and a lawyer. My practice is centered on privacy and data security. It is the majority of the work I do is compliance and governance advisement to companies, rolling out privacy compliance programs, creating governance protocols, and then reacting when something bad happens. So if there's a data breach, if there's a security incident, I supervise the investigation of those incidents and the response as it relates to law enforcement, government, regulators, counterparties, business partners, clients, customers, employees, and all of that. And I also do some litigation in this area as well. So how did we get here? And this is, again, I think, so important in trying to communicate with those around us in our companies. Where are we? What have we had to do in the privacy area in the past before the CCPA? And how does that inform what we have to do now? So I think this is my graphic. This is my way of thinking of this. There are a couple different what I would call major privacy eras that are relevant, at least to the United States. You start with the Wild West. Why were we caring about privacy, in particular consumer privacy, before there were any real laws governing privacy? There was still a notion, of course, of basic fairness, basic transparency, the desire to gain loyalty from your consumers, your customers, your clients, your employees. Of course, there was also there may have been contractual restrictions, even in what I'm calling the Wild West, that that beheld, your company to a certain standard for how it treats its data, how it collects it, how it shares it. And then there was a notion, and even in the quote Wild West, of this right of privacy. And for non-lawyers, this is kind of a wishy-washy area, but you do have, for instance, in the California Constitution, the right of privacy written into it. And so from that has emerged a bunch of case law going back really decades that really creates a fundamental right to privacy for Californians. Similar developments in the U.S. Constitution, of course, there isn't such a specific right to privacy in our U.S. Constitution, but that's what you have in the Wild West. So what what did you really have first as far as privacy regulations? Really, up until I would say the millennium, you had a series of laws. They're highlighted here that were industry specific, that really targeted specific industries, that targeted specific data sets, and imposed specific privacy requirements on them. The first, I think, major example of federal legislation here is the FCRA or FCRA that governed credit reporting. Giving consumers certain rights to contest credit reports, to control the information that goes to the credit reporting agencies, and how it's used. That's an example of a major, and that was back in 1970. HIPAA, we all know about, targeting healthcare, medical data, again, giving basic privacy rights to patients, including limited right to opt in to certain sharing, and things like that. And so that's where we kind of got the first notions of what does a major privacy right even look like? And that was specific only to healthcare providers, healthcare insurers, and other companies that are doing business with those entities. Gramm-Leach-Bliley Act, or GLBA, really at kind of the end in 1999, and then continued to be modified, over the next decade for financial services, consumer financial services in particular, defining non-public personal information, or NPI, as the regulated data set if you are a bank, if you are a credit card, if you're any kind of lender. These are the privacy rights that went there, and they're focused on really notice and opt out. I think then we really saw a turn at the millennium, literally in 2000, where you started to have more targeted privacy rights that were not industry specific. They were much more broad in applicability, but they were still limited as far as what rights are they giving consumers. You had breach notification laws, which we may all be familiar with. Whenever you have a security breach, it's always one of the first considerations. Do you need to notify the victims? These are a patchwork of laws in every state in the country. The first were seen around 2000. In the 2000s, you had in California, I believe, passed in 2002, enacted in 2003. You had the California breach notice law. So broad applicability, but very basic obligations, right? You just have to notify someone if there's been a breach, a security breach. You also, around this exact same time, and in fact in California the same year in 2003, you had the first website privacy laws. The laws that told you that if you're collecting data from a consumer through your website or through some other kind of web-based means, you got to give a basic privacy policy to those consumers. And that was really the birth of what we all are so familiar with now, your basic privacy policy. Here's what we collect online, here's what we do with it. And from that has sprung, of course, a whole set in all 50 states of different requirements. I shouldn't say all 50 states, but many states have different requirements here. And then during this time, as I said, the GLBA was being modified, Regulation P, creating more and more specific requirements about what kind of notice do you have to give to your consumers and to your customers. And then we have really the present. And the last couple of years, you can have whiplash just trying to follow this stuff. But what we have now are comprehensive privacy rights, no longer targeted at a specific industry, no longer targeted even at a specific set of rights like breach notification. Now we have massive comprehensive laws in both Europe and in California that give all kinds of rights to consumers, and they apply broadly if you're a business of a certain size, essentially. And so that's really how we got here, and I think it's very helpful to think about that. And I will talk about the future here in a moment. So what has California's privacy journey been? The topic, of course, of today's whole program. Again, whiplash, right? this is where I think this slide is where, what I try to illustrate as really a plea for patience and understanding, right? So much has happened even in 2020, and I'm not talking about COVID-19. I'm not talking about the presidential election. I'm not talking about the economic, turmoil that's happened. Just in privacy in California, look at all that has happened within the last 12 months. Okay, and January 1st of this year, the CCPA first became operational. We are already talking about a new law, the CPRA, but the CCPA only became operational less than 12 months ago, right? At that point, on January 1st, Californians could file lawsuits for data breaches starting on January 1st. 6 months later, on July 1st, the CCPA became newly and for the first time enforceable by the California Attorney General. So that was the first date that actual privacy violations of the CCPA. So say you fail to offer the right to opt out, say you fail to properly respond to a right to delete, that is now enforceable by the state attorney general, subject to fairly severe penalties, depending on the scale of the violation. That was in July, right? It's now November. We have not been living with this for very long. Just in August, on August 14th, were the final regulations approved. These were kind of the companion rules that go along with the statute that is the CCPA. They're much more detailed. They try at least to give a lot more guidance to companies about how to implement the CCPA, how to interpret it. Those were only approved by the state government in August. And so we've really only had them for a very short time. And again, now we're talking about an entirely new law. And not to be outdone, the Attorney General who makes those regulations proposed new regulations, new modifications to the regulations just last month in October. Those are right now subject to a notice and comment period. They may change, but they're still kind of going on unabated. And importantly, I know the topic of today's programs has been the CPRA, but the CCPA will continue to be in effect and enforceable for the next several years. So these new regulations are just as important, to understand as the ones that were finalized, of course, in August. And then, of course, we had the general election on November 3rd. And as you now know, the CPRA was passed by a majority of California voters. And we're now faced with a new, some would say improved, definitely modified, expanded, and in many ways more strict version of the CCPA, the CPRA. So again, a plea for patience. If anyone, is overwhelmed by what you have to do in privacy compliance in particular, right now, there should be a lot of sympathy because there's been a lot that's happened and it's going to continue to happen in California and the privacy world. So where do we stand now? It really is a complex patchwork that has brought us to today. And I think, this is what I call a heat map that I've kind of tried to put together very recently. And look, it's by no means a definitive reflection of really what all these laws are doing. And it doesn't include all privacy laws here. It's just a sampling of some of the big ones. And again, the coloring here is not definitive either. So green generally means, okay, there is this requirement or this right. Red generally means it's not there. Yellow means there's something in between, okay? And you could debate about some of these. I noticed I put private right of action is green under the CCPA, for example. It probably should be yellow because while there is a private right of action, it only applies to data breaches. But just looking at this, you can kind of see where things are starting to fall. And I think it's important, especially if you work for a company that is fairly broadly regulated by some of these multiple of these laws. It's important to understand where do they all fit together and where might there be contradictions or conflicts. And so this is just a graphical kind of depiction of what we have. I think if you look at it, what are some big takeaways? The far left, the right, what I'm calling notice at collection. This is basically the basic requirement that you provide some kind of disclosure, to your customers about your data practices, about your privacy practices. That's a very broad and kind of the most basic right, and you see it across all of these laws. GLBA, the financial services law. I put CalFIPA up there, which is the California Financial information law, because there, just to illustrate that there are some nuanced differences between the GLBA and California financial law. CCPA, CPRA, GDPR, they all have these requirements. It's in a way kind of the most basic and fundamental privacy right, and we've really had them around for quite some time. So it's easy. It's really the easiest for even non-privacy professionals to understand, right? Everyone understands, okay, we need a privacy policy. We might need some kind of waiver or disclaimer or terms of use. It's very American, right? The American concept of, we're going to inform you and then you have the right to decide what you want to do. That's kind of an American concept. And so we've always been very comfortable with this idea of like, the information's there for you if you want it. And then you can make your own decision about whether to do business with us or give us your data or whatever. What are some other takeaways? You of course see that the GDPR in Europe is still really the most expansive and broad privacy law. You see green almost all the way across the row here. And it continues to be, really the current ceiling on how many privacy obligations you might have that apply to you. And really the question is how much closer are other ensuing privacy laws getting to that standard? And as I'm sure we're talking about today, the CPRA is getting closer to that standard. It's still not there, of course, but it's getting closer. What are some differences here between the CCPA and the CPRA? I think some of the most concrete kind of new developments, of course, are the right to correction. You have kind of certain rights about ADM, that's automated decision making. You do, I think you can, I could have added here, you have very important purpose limitation and use limitation obligations under the CPRA that you don't have, at least explicitly, under the CCPA. You can kind of maybe file that under what I'm calling lawful basis. That's the obligation that you make sure that every reason that you're collecting data, every reason that you're processing data has a predetermined lawful basis. It's a European concept, right? America tends to say, here's a list of things you can't do with data, but we're not going to go forward and just prescribe all of the only ways that you can use data. In Europe, they have somewhat done that, right? We're getting closer to that with the CPRA. The CPRA has codified purpose limitation, data minimization. If you fail to properly minimize your data now under the CPRA, you're actually subject to potential violation. And that's a huge deal. It's a huge development. It really is. And you can compare it to FCRA and FCRA. Again, as I showed earlier, one of the oldest privacy laws in the United States. I think there you have a private right of action, far bottom right on this graph. You had a private right of action in FCRA. So, that's always been a source for so much litigation for us lawyers. Plaintiffs, lawyers who like to sue companies have used FCRA for decades. And I think that should really be a guide about what we're facing now with the CCPA and the CPRA. Plaintiffs' attorneys can use it to make companies' lives sometimes very annoying and very difficult, right? One of the big new stuff, as I said, lawful bases. The rights to delete and access are fairly new to at least to America. And now you're seeing it in California. You're seeing somewhat broad rights to delete, rights to access information, subject to exemptions, of course, but they're there and they apply broadly now. What's the CPRA implementation timeline? Others may go into this in more detail, but again, it's complicated. We're going to continue to have this whiplash effect. But thankfully, we do have basically 2 years to build up to the core provisions of the CPRA. Thankfully, we have extensions of the employment and B2B exemptions that we currently enjoy under the CCPA. Those are going to go into effect immediately. But some of these other requirements are going to be phased in. And what do we mean by operational versus enforceable? Technically the law goes into effect pretty soon, right? But if you read the text of the law, there are a bunch of dates that guide the user about when they go into effect. And those dates are largely in 2022, 2023. Enforceable means what's the first date that the state government can actually investigate you, bring an action to try to penalize you for a violation. That is not until 2023. Quick update on litigation enforcement. Where have we been on the CCPA? So on the left side, what does litigation mean? If you don't know, it means lawsuits. It means getting sued in court by private California citizens. There's generally been three types of cases in the CCPA so far. You have your kind of typical data breach type cases that we're all used to that existed even before the CCPA. There's been a publicized data breach. There's usually a class of individuals who are looking for damages, whether they've actually have proof of actually being harmed or not. And under the CCPA, it's much easier because you have what we call statutory damages. It's a fixed amount that at a minimum you can get $100 per person per violation if you show an actionable data breach under the CCPA. It's a big deal. So that's the main one. 2, privacy violations. So these are more, you're using data in a way that I didn't authorize. There have been a bunch of lawsuits trying to bring CCPA causes of action for privacy violations. Generally, these are not going to be successful because, again, there's only a private right of action for data breaches, but they've kind of tried to shoehorn the concept of a data breach into privacy violations. So there's examples of, for instance, if a company, I'm not going to name names, is using third-party cookies on their website and they're sharing data with another company, what these plaintiffs are arguing is that if that sharing was not adequately disclosed, say in your privacy policy, that is an unauthorized use of your data, and thus it's a data breach. These are the theories that they're trying to bring. We have not gotten much resolution from the courts yet about these kinds of claims. Somewhat because of the pandemic and because lawsuits have proceeded much more slowly. But we do think we're going to get some resolution, on the first cases here, hopefully pretty soon, definitely within the next year. And then you have kind of what I call hybrid or stealth actions. These are ones where, people are trying to say that, oh, you breached a contract or you committed, fraud or you've been negligent, and they use the CCPA kind of indirectly to power those claims. There's still a lot we don't know on the right side about enforcement. That's because the AG has not publicized really anything. They haven't made any formal levies, penalties. They haven't really yet made an example of any company. If they do that, there's going to be a big press push. They'll probably outline the violations. We'll start to get an idea of how they're interpreting the CCPA and how aggressive they are, right, as to certain violations and as to quantifying penalties. They can levy up to $7,500 per person per violation if they think something's really bad, right, intentional violation. What we do kind of know based on comments, from them and other information is they are focusing on do not sell. So if your company is monetizing data or selling data as defined under the statute, they're looking at that. And you can easily tell what a company's position on this is by just going to their website and seeing if they have a do not sell my personal information button on their homepage, and you'd know, right? And so they are focusing on that. They've always and long said that they have a special interest in children's privacy. This is very important to them. It's also reflected, of course, in the CPRA that has now authorized triple damages for privacy violations that involve children's data. So that is a focus of theirs. And just another note here, where are they getting their information? We know there's certainly been indication that the typical route for information is a consumer complaint. You're a consumer, there's a way you can go to the AG's website and you can file a complaint and then they'll investigate it. But what they're also looking at is social media. And so if your company is especially a public facing company with a pretty big profile, it's important to monitor social media. If you have even just one consumer who tweets something out and it starts trending, that may catch the Attorney General's attention. And if you're aware of it, the sooner you're aware of it, the better you can kind of posture yourself and respond. So that is really important. So what does the future hold? We're almost done, but here are some jurisdictions to watch. The CPRA is the CPRA is groundbreaking. The CCPA was groundbreaking. What might the effects be on some other jurisdictions that might be relevant to your organization? Of course, the first one to watch is the federal government. What are they doing in Washington, D.C.? They're not doing much of anything anywhere, right? That's not really a political statement. They're just not doing much. But there is some indication that there's some bipartisan agreement, that privacy law needs to be a federal matter. You can easily see a situation where you have several states that have laws like the CCPA that, while they may be largely in agreement as to the rights, and the obligations, the finer points may disagree, and it may be very hard for a company to simultaneously comply with this patchwork of state laws. And so there's a big desire, including among industry groups, to have a consensus federal law that can be followed, so you don't have to worry about all these different state laws. But therein lies the problem, because this is a concept called preemption. If the federal law is preemptive in nature, that is, if it has the power to basically nullify or knock out state laws like the CCPA, well, then that's very controversial, particularly for Democrats in Washington, D.C., and particularly for Californians. Most of the Californian politicians and elected officials don't want to see that their kind of now pride and joy, the CCPA, just be nullified, right? So that's a big point of controversy for whatever comes out of DC. The current kind of most recent proposal is called the Safe Data Act, or Data Act. That's all an acronym, believe it or not. This is a Republican proposal. It includes some big rights: right to delete, right to access. It does not have a private right of action, which is another big kind of heat point of controversy. So that will need to be watched. And with an apparent Biden administration, perhaps the prospects of something getting done federally are maybe higher. Washington State has kind of been, for a while, the next state to watch for something like the CCPA comes out. It's kind of third time's a charm for them. They have released a third version of what they call the Washington Privacy Act very recently, and it does resemble the CCPA, quite a bit. It has new elements, though. It has rights to access, correct, delete, portability. You can opt out of certain processing like advertising or profiling. It requires risk assessments for certain activities. We are seeing this in the CPRA, like targeted advertising, the use of sensitive data, heightened risk activities similar to what we see in Europe. And there are elements of purpose limitation too, mandated purpose limitation. And up there in Washington State, a major heat point has been the private right of action, should people have the ability to sue for a violation of the Washington Privacy Act. And then, of course, other states, and I've listed some states here. This changes really by the month, but these are ones to watch. You have, and even within some of these states, you have multiple proposals. So, for instance, there are several competing bills right now in Illinois, ranging from quite robust, privacy proposals, privacy laws, to laws that are very minimal. Same dynamic in Arizona. Right now, you have two competing bills that vary wildly. You have two competing bills right now in New York that vary quite a bit. They're called the Right to Know Act and the New York Privacy Act. In addition to Washington State, New York is probably the one to watch also, given what they've done in the past on privacy. And then, of course, you have other states, and I will say there is some private right of action in some of these, proposed in some of these states. Illinois, Maryland, New Jersey, New York, and South Carolina all right now are proposing privacy laws that if you violate them, people can sue you. So that's a major development to watch, and something to really keep your eye on as you talk to your other stakeholders in your company about the importance of data management, of privacy governance. This is all incredibly important. So I thank you for listening. It's been quick. Please shoot me some emails, ask me any questions you have. Add me on LinkedIn, send me a message. I'm happy to talk. I love talking, especially to the Orange County community, about these issues. And I hope you enjoy the rest of today. Again, thank you for listening.